All right. So, hi everyone. Good evening. My name is Niharika Khadge, and I welcome you all to a new session as a part of YLCC's Legal Career-A-Thon series, where we have an expert every week to guide you all. Today, we have with us Ms Devyani Nath, ma'am. Welcome, ma'am, and thank you so much for joining. Ma'am is here to guide us on careers in intellectual property laws. Devyani ma'am graduated from ILS Law College, Pune in 2016 and is currently working as a senior associate in Fidus Law Chambers. She has also worked as an associate in Anand & Anand and Vadhva Law Chambers. If time permits, we shall have the audience's questions at the end of the session. So I request the audience to pin down their questions in the chat box. So without a further delay, let us begin with today's session. So ma'am, first question is, what exactly do IPR lawyers do, and what are the significant responsibilities attached to an IPR attorney? And what are the legal challenges which are commonly faced by IPR lawyers, and what are the main subjects one should be focusing thorough with before choosing to pursue a career in IPR law?
First of all, thank you so much for having me. It's going to be wonderful talking to all of you. Just to begin with, so what exactly do IPR lawyers do? Now, IPR per se consists of a variety of different rights. So it would be trademark being a Nestle is a trademark or Kellogg's is a trademark, copyright, patent, design rights, geographical indication, trade secrets. So it's actually way too many rights that come together, and we call that IPR. So we lawyers, IPR lawyers, basically protect these rights for our clients. So there are various ways in which we protect these rights, which we'll cover eventually. But as the first step, what are the significant responsibilities attached to an IPR attorney is the most important is that you should know what IPR you're dealing with. It is very important to understand the difference between what is a trademark, what is a patent, what is a design. Because a lot of times what happens is a client would just come to you with a piece of paper and say, please protect my copyright. But that exactly would not be a copyright, it would be a trademark. So first responsibility would be, you'll have to advise your client. You'll have to teach your client that what you're trying to protect is a trademark and not a copyright. So these are the different kind of differences that's very important to learn. And once you go into the nitty-gritties of what IPR exactly is, you'd understand that there are so many overlaps within the IPRs that the most important responsibility is to understand the IPR you're dealing with. That's the most important. Second is, you really need to understand the industry your client belongs to. The industry is very important. If your client belongs to an FMCG industry, it's consumer products, you need to understand how you're going to protect your client's right in cases of consumer products. But if it is, for instance, something to do with equipments that are used only in industries, so it's not available to the consumer, then how do you protect those kinds of equipment? So it's very important to understand the industry. The third, or in today's date, the most important responsibility that becomes is to basically keep up with the technology. Every day we have something or the other new coming up. We will have AI, we will have Bitcoins, we will have currently there's a lot of issues going on with Twitter. So you really need to understand how the technology is working. Because if you understand AI, then you'd know how to protect a trademark in AI, how to protect a trademark in Meta. So it's very important to understand the upcoming technology. And the legal challenges that are commonly faced by IPR lawyers. And this, it's been 6 years since I have been practicing in this field, and I have seen a major difference in how people deal with IPR. When I had started, I would have clients come to me and be like, oh, IPR does not matter. We don't have to protect IPR. Their mark would be used by, it's a very common product. They'll come up with copies of that and then use it in small shops, and then the brand gets diluted. So the most important legal challenge is to make your client understand how important a trademark is or how important an IPR is. If a client does not understand the importance of IPR, it becomes very difficult to protect it, because after a certain point of time, it's very difficult to protect anything, be it IPR or any other rights altogether. So making your client explain how to protect IPR is the most difficult challenge that I have faced in my career so far. Other than that, sometimes what happens is there'll be overlaps between your different IPRs. So the challenge is how you decide to differentiate between the IPRs, how you decide to protect each IPR separately. So for that, the most important thing is you really need to understand, as I said, what is the IPR you're protecting, whether it's a trademark, copyright, etc. And what are the main subjects one should be thorough with before choosing to pursue a career in IPR law? The 4 basics is trademark, copyright, patent, design. Your career is going to revolve around these 4 major laws, and it's important to understand these 4 major laws properly. While trademark says registration is not mandatory, a patent or design would say registration is mandatory. While a trademark would say prior use is very important. Prior use basically being that before I start commercializing my product or launch my product, if I can show that I've used it prior to that date, it becomes very important to establish the importance of that brand. But if it's a design and I have used the design prior to getting my registration, then my design will be invalidated. I will not have any rights on my design. So it's very important to understand how a trademark works, how design works. Now, the other subjects, if you want to be an IPR litigator, be thorough with CPC. That's the number 1 lesson that I learned. I'm an IPR litigator. That's the number 1 lesson I learned. If you know the CPC, then you will definitely know how to deal with IPR laws. In CRPC, CPC, Civil Procedure Code, a criminal procedure code may not be as helpful in IPR, but Civil Procedure Code is the most important. So yeah, that would be the main subjects one should be thorough with.
Right. With regards to the previous questions, what are your roles and responsibilities as an IPR attorney at Fidus Law Chambers, and how does your typical workday look like?
So I'm an IPR litigator. So my main profile is protecting the IPR in courts. So I go to court every day. I will be filing cases almost every week. I'll be getting injunctions on the first day. Then I will go and conduct raids, seize the products that have been injuncted or used or are found to be non-genuine. So that primarily would be my role. In addition to that, I also work on contracts. I help clients decide how to protect their IPR by drafting really strong, solid contracts, solid transactions and agreements. Then I advise clients whether they should actually go for litigation, because a lot of times the clients will just come to me with this one proposition that I have found this person using my design, my design of a helmet. How do I stop that person? Now, a lot of times what would happen is we will look at the facts and we'll be like, okay, this is necessarily not identical to your design. So you really would not be able to get a favorable order from court. So then we advise the clients and then we say, okay, instead of going for a design, going for litigation, why don't you just amicably approach the other side and try to get like a settlement offer or try to, amicably ask them to not use the design. So these are the various kinds of advisory jobs that I do. And my typical work day is I reach court at 10:30. I will do about 5 to 6 matters that day. And court being Delhi High Court, my practice is primarily Delhi High Court. And I will do 5 to 6 matters. Then we will come back and then we will brief our seniors for the next day's matter. We will draft, we will advise clients. So that's a typical work day for a litigator. The most important is that you need to be very thorough with your files. And yeah, that's about it.
Right. Thank you so much. How has the IPR domain evolved over the years, and what is the scope and the possible opportunities in this field at present? And what are the key skills that are most valued for an IPR career?
So this is a very interesting question. So when I started 6 years back, I started from a small team. It was a small law firm. My senior, he had just started off about 3 or 4 years back. So the clients that used to approach him were not your big companies. They were small traders who used to come to him and be like, okay, someone is using my trademark. What do I do? Back then, the awareness with the proprietors of these IPRs was not as much as it is today. In 2016, it was very difficult to convince someone to actually go to court and litigate and actually get an order, because they used to be like, why should I spend so much money on just getting an order which stops the other person from using my mark? May as well just let the other person use, and I can do something to advertise and make my mark better. But today, with so many startups coming up, every startup will have this one specific factor or sector where they're only focusing on IP. So before they launch, they will make it a point that the trademark application is filed. Before they launch, they will make it a point they have all the contracts in place. All their advertisements are in accordance with all the IP laws. It does not infringe anyone's rights. So today, startups are very much focused. All your big companies have separate sections, separate legal departments which deal with IP only. And those legal departments will actually say, okay, no, we found this small entity. We want to send them a legal notice. We want them to stop using our mark. So there is a lot of involvement. Then even your courts, I believe you'll be covering that eventually, but even your courts have now started understanding that how important IPR is. You have separate divisions in Delhi High Court. Bombay High Court is coming up with separate divisions. So you will have judges who are experienced in IPR who will only listen to those IPR cases. So now you have more well-reasoned orders and well-thought-of orders as compared to earlier. Because earlier, so today, if I go for a matter before a specialized IP judge, he will pass an order within 1 month. Earlier, I would go before any judge and they would actually take 2 to 3 months to understand. If it's a technical patent matter, they would take 2 to 3 months to understand the science behind it, to understand the law behind it, then pass the order. So that way, there has been a lot of evolution in the IPR domain also. And as regards the key skills that are most valued for an IPR career, as I had said, reading. If reading is must, you need to just keep up with the evolving technology, read and understand your customers' industry, your client's industry. If you don't understand your client's industry, it will be very difficult for you to pitch a case or pitch an issue and get any kind of favorable orders.
Right. Now moving on to the next question. What can a law student in India do to prepare for a career in IPR? And how can a law student prepare a roadmap for himself or herself in this domain?
A law student in India to prepare for a career in IPR. Now, I'll tell you what I did. I decided to pursue IPR in second year of college. The first thing I did and how I decided that was there was this one moot court in college, and that had a specialized case on IPR. And back then, it was not a very common practice to have specialized IPR cases in moot courts. Now you will have a lot of moot courts which specifically deal with IP laws. Back then, that was not the case. And I came across that one case. It was a very interesting case where in an advertisement, a protected design was displayed in an advertisement. So we had to basically figure out whether that display of that particular design in an advertisement would amount to an infringement of the design, or would it be fair use? So that's what got me intrigued, and I really liked the IPR after that. And then I enrolled for a diploma at Symbiosis Law School. It was a very interesting diploma. It was a 1 year diploma, and we learned a lot. Because generally what happens is in college, you will have 1 semester, 1 subject, which will cover all your IPR, trademark, copyright, patent design, all covered in that 1 semester, 1 subject. So it may not be enough to understand each and every subject separately, each and every IP separately. So I had enrolled for a diploma. Now, diploma could be something which may not be very easily accessible to everyone, but nowadays we have a lot of online courses, so diploma becomes accessible. But another very interesting thing that one can try to understand what IPR is. So World Intellectual Property Organization has these free courses online, and they're very helpful courses. They will actually give you the basics of what IPR is. So I think it's best to go for these courses, go for these diplomas if you have the time, if you have the energy to pursue a parallel course. If not, keep reading. There are many blogs. You can cover those blogs. I started with Spicy IP. Spicy IP used to be my fuel to understand what IPR is. And today also Spicy IP covers it brilliantly. But other than Spicy IP, you have WIPR, you have FIPO blogs, you have Mondac has a lot of IP pieces that they cover. So keep reading these articles written, because these articles are also written by people from the industry. So my colleagues have written a lot of articles. So we actually put in a lot of our industry understanding on how to deal with an issue. So it's very interesting. Keep reading, do diploma courses. And another diploma course that's very, very interesting that anyone can try, it's generally available after completing 3 years of college, is by NLSIU. NLSIU is an IPR diploma, which is for 1 year. Very interesting, very easy to understand. That can be tried. So this is how one can prepare for a career in IPR in terms of studies. In terms of the next important thing is in terms of actually understanding how to be in the industry and how to work is internships. Do IPR specific internships. Intern with small chambers, intern with big law firms, but do IPR specific internships. Intern with independent lawyers. That also teaches you a lot. You will understand so many nitty-gritties of law. There are, like, when I said that IPR has evolved, IPR has not only evolved in terms of how the courts are functioning today or how the technology has changed. IPR has come into so many domains. Media has also become a very important part of IPR now. So everyone wants to protect their songs, protect their copyright, how to portray themselves on the through advertisements and everything. So internships is very important. It's how can a law student prepare a roadmap for himself or herself in this domain. Again, it's related to what I was saying earlier. Understand, if you're very sure of IPR, do diploma courses, read blogs, write articles, do internships. If you do internships specific to IPR, it becomes a lot more easier to get a job in that IPR field. Now, it's not necessary to do an internship in IPR litigation, or to do an internship which focuses on prosecution being filings, or it's not important that you focus your internship on the contractual work or advisory work. Any kind of IPR internship, if you keep doing those IPR internships, it will help you get a job in whichever field you want to go to in IPR. Yeah.
Right. Could you please provide a list of courses or top IP journals or blogs in IPR that according to you can be beneficial for law students? And how did you prepare yourself in this domain? So like right now you mentioned about the top IP journals and diploma courses which we can do. So if you have anything to add, we could continue with this question, or I could move on to the next question.
So it's kind of like a recap. Now, in terms of courses, as I had said, NLSIU offers a very good course. Symbiosis Law School, I'm not sure if they continue to offer that course, but they used to offer a very, very good course of diploma in IPR. And there are a lot of courses that are now available online where you can learn the basics of IPR. And in terms of what are those specific online courses, I can actually NLSIU, in fact, is a distance education course. It's you don't have to go for physical classes. They actually send you the books. You have to read on your own. Their classes are conducted online. These are these are not mandatory classes. It's up to you whether you want to join those classes. And then you just have to go to the center and give a written exam. So that's the NLSIO course, which is available after completing 3 years of college. And in terms of blogs, I started with Spicy IP because that time Spicy IP was the most important blog. But nowadays we have way too many blogs that have come up. We have Median, we have Spicy IP, we have WIPR, INTA have a lot of articles that they keep publishing. So yeah, that covers everything.
Right. Since most of the law students want to acquire a role at leading law firms in India, could you please list out some of the top IPR law firms in India? And how can a law student or a graduate approach such firms? And what strategies should they incorporate?
Now, in terms of the leading law firms, now what I have observed is IPR is when we are dealing with trademark or patent law or design law, anything to do with anything apart from copyright law, the focus is in Delhi. So you will have a lot more trademark related work, a lot more trademark related judgments coming from Delhi courts. And you will have the focus on copyright in Bombay. So if I tell you the leading law firms in Delhi, Anand & Anand obviously is the best in IPR. And if you get an opportunity to actually interact with Mr. Praveen Anand, you will understand that it's the place is really good and he's very knowledgeable and he knows the law very well. So Anand & Anand is best. Other than that, we have Sai Krishna. Then we have Lalin Sethi, Singh & Singh. Singh & Singh was the firm that Justice Pratibha Singh had started initially. So Singh & Singh is there. And then you have mid-tier firms like Fidus, Mason, Sakarchandra and Associates. These firms are doing really well. So these are some of the top firms that one can keep an eye out for if you want to really work in the field of IPR. And how can a law student graduate approach such firms? Now, one thing is that I have noticed with the big law firms, if you come from a good college, good grades, it is easy to get into these places. But I do understand that that's not fair. I mean, why should it be restricted only to those top tier colleges? It's not fair. So how to overcome this? Be visible. How do you be visible? Networking. Know someone who is at that place. Talk to that person. Show that you're interested. Ask that person to get you an internship or ask that person how I can apply for an internship there. Whether then that person can give a recommendation to get an internship. Once you get an internship, be proactive. Actively go and ask for work. Deliver your work on time. Show that this is what you have done. So that's the second part. Be proactive. Write articles, blogs. A lot of these big law firms, they really appreciate if you are writing and if you're showing that you have an understanding of the field. Because when you write articles, that actually shows that you understand what you're dealing with. So that's how it really works. So that's how one can approach such firms. And the strategies they should incorporate, again, it would be the same. Networking is the most important. In the law field, networking is the key to actually survive in this field. And then comes the actual hard work, reading, writing, understanding the law, making someone explain how complicated IPR is and simplifying it. So those are the strategies that one could incorporate.
Right. In 2021, the Delhi High Court has created the Intellectual Property Division in Delhi High Court to deal with matters related to IPR and formed the Delhi High Court Intellectual Property Rights Division rules for the same. So could you please share your opinion on these rules?
So this was a very welcome change for us IP litigators. We were relieved when the IP division was created. Prior to the IP division, so Delhi High Court, just not to make it hyper-technical or complicated, just a simple understanding, Delhi High Court has one section which deals with original matters. Original matters being if you're within a particular pecuniary jurisdiction, you can directly go to the Delhi High Court and file a suit. So there are a lot of courts which do not have this original jurisdiction, so you have to go to the district court. So Delhi High Court is one such court which has that original jurisdiction. So earlier, all our IPR cases used to go to those 6 or 8 judges that used to sit in that original division of the Delhi High Court. We have judges who had never dealt with IPR before. So they had just got the IPR matters, and they were dealing with patent cases for the first time. And patent cases are very complicated because other than understanding how your patent has been infringed, you have to also explain what the patent is. So you have to explain the science behind it. It's a pharma matter. And I have done quite a few pharma patent matters, and I can tell you it's very complicated. And I don't even come from a science background. For me, it was very difficult to understand what that pharma patent I'm dealing with. So for those judges who had not come from an IP background, who had never done IPR practice when they were lawyers and advocates, it was very difficult to make them explain and understand the IPR we are dealing with. So that, and then other than this, there was a lot of backlog. We used to file one case, say I filed a case in March. I had to wait for 2 years to get a judgment on just my interim prayer, on just an injunction that I want in the interim before the suit is finally decided. I had to wait for 2 years for that. And in 2 years, in a way, the commercial benefit of filing that suit kinds of gets lost for the client. So it was very difficult to deal with matters prior to the IP division. Now, when we have the IP division, there are 3 judges in the IP division right now. All 3 judges come from some of the other experience in the IP field. One of the preceding judges is Justice Pratibha Singh. She had her own IP practice. She was a senior counsel who used to deal with only IPR cases. Then we have Justice Jyoti Singh, who also used to deal with a lot of IP cases when she was an advocate, and Justice Naveen Chawla, who has had an opportunity to deal with IP cases when he became a judge. So the important thing that happened with the IP division is now we have specialized judges who understand what IPR is. The other thing that happened is if I file a case today, within 3 months, I'm going to get a judgment on my interim relief, which is very beneficial for the clients, which is very beneficial because the commercial benefit is met of filing a suit. It's much quicker, it's much faster, it's easier to explain. So that way, it's very good. There are obviously pros and cons because even with 3 judges and the number of cases that are being filed on a daily basis, I see in the High Court cause list that approximately 20 new cases would have been filed on a daily basis divided between 3 judges. So there's a lot of workload, because of which sometimes there are delays, sometimes the judges would not have the time. So one thing is we would need more judges in the IP division, and we would probably need judges who specifically deal with patent matters or who specifically deal with copyright matters. Now, another thing that happened with the IP division, just to go into a little bit of technicality. So there was one tribunal called the Intellectual Property Appellate Board, which used to deal with matters that used to come from the prosecution side of IPR. Prosecution side being if I filed a trademark application and the examiner of the trademark application refuses my application, I can go and appeal to that order to the Intellectual Property Appellate Board. So that was the tribunal that used to deal with these kinds of matters. Or I have come across a mark which is registered, and I want to say that this mark should be cancelled, then I go to the IPAB for that. So the IPAB ceased to exist in 2021. So all the workload of IPAB also shifted to the High Court. So under the Delhi High Court IP division, we also have the matters that the IPAB used to deal with. So every day we will have at least 10 writ petitions filed or 10 petitions filed where they are dealing with refusal of a trademark, or they're dealing with refusal of a patent, or they're dealing with cancellation of a patent, cancellation of a trademark. So we have a variety of cases that have come under the Delhi High Court IP division now.
Right. Moving on to the next question. What are the general advantages of alternative dispute resolution in the intellectual property disputes?
ADR is the key to solve all the workload, all the backlog that is there in the courts today. And courts have made it mandatory now that prior to going for a litigation, you have to do a pre-suit mediation. It's basically you file a petition in court saying that, listen, I believe that there is some kind of dispute that I may have with the other person. I want to sit before a mediator and talk and try to amicably resolve the dispute. And so many cases do get resolved through mediations. There are a lot of times when I have filed a matter and the court will be like, why have you come to court with this matter? Go to the mediation center, settle it. And a matter which would have dragged on for 6 to 7 years to get final conclusion will get concluded in 3 to 4 months. So that means ADR is very important. But this ADR that I'm talking about is once I have initiated the litigation. Prior to litigation, often what happens is, if you see that the other party is using a mark which is similar to your mark, but you think that the other party also has a strong claim to use that mark, you can just simply go to the other party and say, let's just sit and discuss and figure out a common ground around this. It saves a lot of costs. It saves a lot of time. It avoids backlogs in the court, and both the parties will be happy at the end of the day. There won't be any fights. So ADR is very important. Another very interesting kind of ADR that I often deal with is I deal with one of counterfeit product matters. Now, counterfeit products are basically those non-genuine products that are being sold. So you'll have medicines which are not genuine. Those medicines. So we file cases against those small traders and sellers who are selling these counterfeit products, get a first day injunction, go and conduct a raid at their premises, seize all their products. So in a way, they stop doing the business. Then after a couple of weeks, the matter will be before court. They will come and they will be like, okay, I want to go in mediation and settle this matter. We go to mediation and then we start disputing or start fighting on what the damages should be. Because the small trader should come and pay me some damages because I had to bring him to court for him to stop using the mark. So those are the kind of areas that I deal with. And it's very interesting to converse with those small traders and make them understand that what you're doing is wrong, because the small traders will come and be like, oh, I thought it's genuine when I was selling it. I purchased it from someone else. How does it matter? But then you have to actually make them understand, no, what you were selling was not genuine. I have incurred so much cost. You have to pay something to me. So that's a other kind of area, because if I do not settle the matter in mediation, the court is going to pass an order where if the small trader would have agreed to give me 50,000 damages, the court will say that no, the small trader should pay 3 lakh damages. So then obviously it becomes very difficult for those small traders. How will they arrange for 3 lakh rupees? So ADR is important that way. It helps in getting a quick redressal to a dispute. And I often always suggest my clients that before you go for a litigation, try to see if you can resolve this dispute through an amicable a meeting to amicably resolve the dispute. If that works best, then that's always better.
Right. Moving on to the next question. Could you please lend your thoughts on Uniform Domain Name Dispute Resolution Policy? And do you think that the dispute resolution has gained importance now for resolving major IP disputes?
So UDRT. Now, this is a very interesting domain. And if any of you are interested in domain name disputes, you should actually follow this one particular matter that I will tell you after this question is complete. So basically, domain names, what would happen is, for instance, I have a trademark for Devyani and I use Devyani.com, and I sell very, very important and useful products. And or let me give you a practical example. Snapdeal.com. Now, Snapdeal is technically an e-commerce platform, and Snapdeal will have all these offers where there are lucky draws happening and people are winning a lot of prizes and everything. What happened was a lot of these third parties started coming up with domain names like snapdealluckydraw.com or online lucky draw snapdeal.com. So they were using my trademark to get all the traction. But what they were doing is they were posting fake content on their website saying that, listen, you have won a lucky draw. You have to call me on this number, deposit some minimal amount of 10,000 rupees, and I will give you whatever you won in that lucky draw. And because of which so many people lost money. We filed cases, we got final judgments on this. And this is one example that I'm telling you. Currently, there is this one matter that Justice Pratibha Singh is dealing with, which deals with 30 cases where these instances are happening, 30 different brands where this is happening, where these domain names will crop up and these domain name owners will not have any rights to use those domain names, and they will crop up. So one way to deal with domain name disputes is go to the court. The other way to deal with domain name disputes is to file a complaint under Uniform Domain Name Resolution Policy. Uniform Domain Name Resolution Policy is governed by the World Intellectual Property Organization. So what you do is you will file a complaint under UDRP to the WIPO saying that I am the right owner. I have the right to use this domain name. The other party does not have any legitimate right to use this domain name. So please stop the other party, either transfer the other party's domain name to me or cancel that domain name. As a general procedure, WIPO will appoint an administrator who is actually going to pass the final judgment, serve a copy of your complaint to the proprietor of that domain name, that infringing domain name, ask the proprietor to come and give a response, and then pass a final order. A lot of times what happens is the moment it is served on the respondent or the other side, they will just come and say, oh, I by mistakenly registered this domain name. I am willing to give up this domain name right away. So it's a very quick way to deal with domain name disputes. So that's what UDRP is. And do you think that the dispute resolution is getting importance now for resolving major IP disputes? Definitely. If you want the quickest remedy to any IPR disputes that you have, go to court. That's the quickest remedy. You can prepare the papers for filing within 2 to 3 days. And on the first day itself, you can get an injunction which stops the other party from using it. That's the quickest way to deal with disputes. But going to court is also very costly. In the High Court, if you want to file a case, your client will have to actually pay just 2 lakhs as court fees. So just for court fees, they will have to shell out 2 lakhs. Then they will have to pay fees for your drafting, appearance, everything. So it's very expensive. So that's why a lot of times clients don't want to go for litigation. They may just say, let's just send a legal notice and see what happens. Or if it's a domain dispute, then they will say, okay, fine, I would prefer UDRP. Let's just see what happens under UDRP. If it does not happen, then we'll consider court. But dispute resolution has gained a lot of importance with the number of cases that are being filed and the number of judgments that we receive on a daily basis. I believe that's the best way to deal with any IPR dispute at this moment.
Right. The Snapdeal example was very beneficial to understand the concept in its entirety. So now we can move on to the questions from the audience. If anyone is willing to unmute themselves and ask the questions, they may, or they can also type in the chat box. I can read it out. So ma'am, first question is, what is the full form of LSCI?
LFCI.
Ma'am, I might have been mistaken, but you mentioned courses like WIPO courses, FICE, IP's blog, and you mentioned something like LSCI. Maybe was that NLSIU's diploma?
NLSIU.
Okay.
Yes, okay. I was also a little confused as to LFCI. It's National Law University, Bangalore. They have these diploma courses available after completing 3 years. So basically, you need to be a graduate to get to enroll for those diploma courses. And one specialized course that they have is for IPR, intellectual property rights. So I have done the course that I did from NLSIU was for Masters in Business Laws, where they also covered intellectual property because IP becomes a very important part in business laws as well. But they have a specialized course for IPR where at the end you actually have to give a dissertation on a topic of your choice that actually helps you in understanding what exactly goes in IPR.
Okay, thank you, ma'am.
Ma'am, may I ask a question?
Yeah.
So, ma'am, you had talked about a matter, I think it was a moot topic where there was a protected design which was being used in an advertisement, right?
Yes.
So, what would be the answer to that? Can it be considered infringement or would it be fair use?
So, that's a very tricky situation. So, generally, when moot courts are drafted, they always have points from both the sides. Yes. So there was no final conclusion to that problem. But it's very common to see Dettol and Lifebuoy fighting. And often you will see it's a Lifebuoy ad, which will have the Dettol bottle, the white bottle with the green cap, and it will just remove the trademark Dettol from it. Whether that would amount to infringement, maybe, maybe not. It entirely depends. The key is to basically in comparative advertising, what happens is, if I'm saying I'm the best, and if I have proof to say I'm the best, that's okay. But if I'm saying I'm better than you because you are bad in A, B, C, D, that is wrong. That is defamation. So that is considered to be disparagement, and that is definitely stopped. Now, in this moot court, what had happened was, this was a moot court by, okay, let's just take an example, Morteen and All Out. So All Out was the plaintiff. Morteen had come up with an ad to say that, listen, I'm the best good night, the mosquito repellent right now. And in the background, they had shown All Out's device. And they had said, listen, there are so many mosquitoes around All Out and they're not dying, but listen, mosquitoes around me are dying. So that, in a way, can be considered to be disparagement, because you're trying to say that that product is not at all efficient. It's not at all effective. So this is how it's basically judged. You have to see whether you're actually defaming the product, or you're saying that you're the best without having the proof to say you're the best. Those are a few key factors to understand which side would win in these kinds of cases.
If I'm not wrong, there is a Domex and Harpic case in that,
Yes.
which happened
The most
famous one, if I can remember.
Yes. Very recently, Lux and Sebamed were fighting on soaps. Sebamed had come up with an ad where they were showing Lux soap, and they were showing the pH level of Lux soap to be equivalent to Rin detergent. And Lux won. And Lux and Sebamed keep fighting. Dettol and Lifebuoy keep fighting a lot. Domex and Harpic, yes. Domex and Harpic, there was a time when in Domex ad, they used to actually take the name of Harpic. And then all of this was I wouldn't say stopped, but they tried to regulate it. Just to stem from this, in advertising, another very important, in IPR itself, another very important thing to understand for advertising is the ASCI. This is the Advertising Standard Council of India. This is just a self-regulatory body, but it's very important that you read up on what ASCI is, how ASCI also governs IPR. Because if, for instance, you are advising an influencer, ASCI has guidelines which say what an influencer can do and what an influencer cannot do. So advertising has also become very important in the field of IPR.
Okay, ma'am. Thank you.
Coca-Cola and Pepsi.
Yes, Coca-Cola and Pepsi. That's been the oldest dispute so far.
Right, moving on to the next question. How to transition from a normal litigation practice to IP specialized practice? And is it difficult to join IP specialized firms?
It isn't difficult, but one thing to remember, if you have 5 years of civil commercial litigation practice and you're joining an IP practice, you will be starting off as a fresher. So you would know how the courts function, you would know how to get your order, how to get your judgment. But since IPR is technical, it is specific to the particular IP that you're dealing with, you will be starting off as a fresher, because in order to apply your civil practice to IPR, it's actually learning from scratch. It is not at all difficult. There are a lot of firms who look for litigation experience. In IP litigation, they look for litigation experience so that the person knows how basic drafting is done, how to conduct oneself in court, what kind of hearings happen before lower courts, what kind of hearings happen before higher courts. So these kinds of basic understanding that person would have. And then if you're really interested in IPR and you show interest, then they will obviously be willing to teach you what trademark is, what copyright is, how to deal with these things. I mean, in my firm itself, I have seen instances where my firm has hired people from civil litigation practice for IP litigation practice. And we are very open about, I mean, if we see that there is potential for growth in IP litigation, we do hire.
Right. Could you please explain about patent agent and their scope?
A patent agent. Now, patents are very tricky. Now, what happens is, if I want to fight a case in court, I don't need to be a patent agent. But if I want to file a patent application, I need to be a patent agent. A filing of a patent application is very complicated. It's not just telling the examiner that this is my invention. It is actually writing the claims that I am seeking protection on, the specifications of that patent, the drawings of that patent, the abstract of that patent. There's a lot that goes into just getting protection for that patent. And patent is one right that does not, you do not get protection for patent if you don't have registration. So it is absolutely important to get registration. Otherwise, you will not have a patent on your invention. So a patent agent does this registration part of it. So anything that happens before the patent officer till the stage of filing would be done by a patent agent. In order to become, and then you have to give an exam to enroll yourself as a patent agent. It is not that today I can just simply go online and log in and say that I'm a patent agent. You have to actually sit for an exam where they give you practical examples. You have to write, draft, complete specifications and claims. They check whether your drafting is correct or not. And then they go ahead and give you the designation of a patent agent. And the most important qualification that educational qualification that you need to have to become a patent agent is science. Either you do science till 12th or you have a BSc, but you need to have a science background. So without just a simple LLB without science will not make you eligible to sit for the patent agent exam.
Right. Since IP laws are similar in many countries, are there any international opportunities for Indian lawyers?
It's difficult, to be very honest, in terms of litigation to practice in other jurisdictions. A lot of these jurisdictions, before they give you a job, they have this criteria of completing some kind of education. That's will be LLM or JD in US. So you will have to do that education. You will have to enroll in the bar to practice. The other thing is paralegals. Now, paralegals in India are slightly different from what it is in other jurisdictions. You can go and work in law firms as paralegals. Paralegals also deal with the filings of your trademark, basic enforcement work. All of these are dealt with by paralegals. They actually help you come up with advice on how to deal with this particular dispute. You can try to apply for jobs, but a lot of these foreign companies would want you to be qualified to practice in that particular country or have some kind of educational background from that country. And another thing very important to understand is IPR is not a standalone law. IPR is always connected with all your other laws. IPR will have tax laws, which become very important. IPR will have your civil laws that become very important. IPR will have your basic contract law, which becomes important. And these tax, civil, contract law changes jurisdiction-wise. So it's very important to have an understanding of that particular jurisdiction's special laws, and then you can apply it to IPR. And even in terms of IPR, there are certain laws which may be differently protected in US as compared to what they're protected in India. So a kind of educational qualification from educational background from that country is kind of becomes important to get a job.
Right. In IPR litigation, mostly a lawyer deals with trademark cases. So where do we stand as a chance in patent or design litigation?
In Delhi, we have a lot of patent litigation matters. There are a few firms that specifically deal with, I wouldn't say specifically, but majority of these patent litigation matters stem from a few firms, one being Anand & Anand, second being Sai Krishna. They have quite a few patent litigation matters that they are arguing on a daily basis. And the patent matters that I see in the Delhi High Court are not only for pharma, they're also for your technology that goes in a phone, your essential patents. So those kinds of patent matters also there are. Yes, the major chunk of it is trademark because to be fair, trademark is, from a customer's point of view, protecting your trademark becomes the most important if you want your business to be to flourish and to be protected. So that's why the most important is trademark. Design, there isn't much. To be very honest, there isn't much of design because design, we still need to educate the industry a lot more on design and how to protect the design and what is the importance of protecting one design. So we're still evolving in the design law sector. But yes, otherwise, there are quite a few patent matters.
Right. How does one choose a niche for themselves in IPR, for example, between trademark prosecution and trademark litigation?
That's entirely up to you. If you want to spend your entire day just fighting in court, go for litigation. Trust me, if you love debating, that's how I decided I want to be a litigator. I still love debating, and then I was like, okay, fine, let me just try my hands in court. I really liked litigation, and I stuck around. So it's up to you. You want to go through that entire rigmarole of filing a case, appearing before court every day, fighting the matter, arguing before the judge. If you like doing that, give a shot in IPR litigation. Otherwise, if you want to protect the brand from stage one, because a litigator will come into the job of a litigator would start when the trademark has already come into existence. But in prosecution, you're actually giving birth to that trademark. So a lot of clients will actually come to you to coin a brand. So you're helping the client coin a trademark, then register that trademark, ensure that the registration survives. There are no proceedings against that registration at the trademark registry stage. So it entirely depends on what your pick is.
Right. Ma'am, any final advice for the audience members?
Read, keep up with technology, and understand what IPR is before you actually decide to jump into it. It is very interesting, but it's also very technical. So you need to be very, very much prepared to know that IPR is going to be tough. Yeah, that's about it.
Right. As much as we would love to take all the questions from the audience, since we are running on time, I think we should conclude. So we come to an end of this session. Thank you so much, ma'am, for joining, and thank you so much for a wonderful session. And I'm sure everyone was busy taking notes throughout the session because it was very insightful. Again, thank you, ma'am. Thank you so much for agreeing to join this session after an exhaustive work week. And thank you all for joining, especially on a Saturday evening. So I wish you all a happy weekend. Thank you for joining. Good night, everyone.
Good night, everyone. Thank you so much.